Hayden Fontanet, Mr. Rojas, at the sentencing. Good morning. Are you Hayden
Yes.
Fontanet? And this is 25 DCCR 1759. Mr. Fontanet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. It's definitely is, Judge.
Are there any additions or corrections to the report?
Not from the defense, not from the state, Judge.
And Mr. Coleman, you said you have a witness or some evidence?
Actually, Judge, Mr. Rojas has graciously stipulated to the admission of the surveillance video from the convenience store in question. So
Okay.
I need to call my custodian record. With the court's permission, first of all, I'm offering states one. No, Judge.
Make that states two, because this one was the plea admonishment documentation, please.
I'm offering states two. No objection.
States two's admitted.
Permission to publish, sir.
Yes, sir.
Judge, I think that's all I wish to publish unless the court wants to see the entirety of the video.
I think that's enough. Any other evidence or witnesses?
So just brief argument if I may.
Any other evidence or witnesses for Mr. Rojas?
No, Your Honor, just
Mr. Rojas, you may make argument first.
Thank you, Judge. And obviously, after seeing that video, it makes what we're asking for harder to do. What we're here asking for this morning, Judge, is probation. Mr. Fontanet, he is a young offender. I know the court is tired of hearing the same story over and over again, young guys with guns in here. He's got a limited criminal history. I believe this is his first felony. He's never been on any kind of felony supervision or felony probation. Unfortunately, he's just fallen into the same situation that we see so many other youthful offenders fall into. He's got no direction in life. He's very little supported at home. Sees no way out of the situation that he's in, so he goes and decides to rob a store and get some money. Did the wrong thing. And if his story in the PSI is to be believed for what I believe is the right reason, he's trying to help his mom at home, trying to pay some bills, keep the lights on. Certainly there are better ways to go about doing that. And I hope that the time in jail has taught Mr. Fontanet that.
You can already see where the defense is going. They are asking the judge to look beyond the crime and focus on the person. But in violent robbery cases, good intentions rarely outweigh what actually happened.
If this conduct continues, he's on the road to prison. I don't know that today is the best time to make that exit. We've got options here, Judge. We can send him to prison. He's got a long life to live. We can send him to prison. Certainly, for a few years. He's on the road. I don't know that he's going to get the help. If this conduct continues, he's on the road to prison. There are programs available. Today is the best time to make that serious about turning his life around, like he says in the PSI. He's got a long life to live. We can send those programs can help for a few years and come back. And if he does take advantage of that he really needs in prison, in turn, there are programs available on probation that if he's serious about turning his life around, like he says in the PSI, when he does get out of prison, if those programs can help him. And if he does take advantage of living at home with his mom, I think this in turn will make younger siblings community a little bit safer. To his benefit, before he was even arrested, he started a GED. I think on the night that this happened, he had just finished a GED. Living at home with his mom, I think that's a decision younger siblings should not have been hanging out with. To his benefit, before he was even arrested, he started a GED. Again, I think on the night that you've got two options, you can send him to prison or GED, try to get some help on probation to go hang out with these guys. Hopefully he's not going to hang out with it. And certainly if he doesn't, we're going to know pretty quick. And you'll have another chance. Again, Judge, you've got two options. You can prison probably for a longer time. You can try to get him some help on probation.
Thank you.
And hopefully he'll take advantage of that. Certainly if he doesn't, we're going to know pretty quick.
Are there co-defendants? Have they been charged?
They have been charged, Judge, and I have both of their cases.
And they have not been sentenced. What is the status of other two?
Yeah, I'll be brief. When it's the Pine Club apartments or Rogers Park or a Speedy Mart, you've seen this and we've seen this in this community all too often. I'm preaching to the choir, Judge.
All right, go ahead.
Prayer vigils, I'll be brief. When it's the Pine Club apartments or Rogers Park or a Speedy Mart, you've seen this and we've seen this in this community all too often. Protect the community. I'm preaching to the choir, Judge. Like prayer vigils and you are that person in your communities. All that stuff's fine. That you judge where the rubber meets the piece of paper. You are conditioned. You are that person that you won't resort to this kind of violence that you saw like on this video, or you are that person that community is safe to let him by putting him behind probation bars with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on the video, or you can ensure that the community is safe by putting him behind the message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this. I'm not hesitating. You pick up a gun with intent to commit violence, you're going to pick up a 15 to prison message it needs to be sent to this defendant and his circle of friends and anybody who would want to be like this on behalf of the people who live pick up a gun with intent to commit violence. You're gonna take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a speedy mark that you convenience do this on behalf of pick up people who live at the Pine Club apartment. They just want to live in peace. People who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a speedy mark.
So, Mr. Fontenot, there was a time some years ago that there really wasn't.
That argument completely shifts the focus. Instead of talking about the defendant's future, the prosecutor reminds the court about every innocent person who could become the next victim.
Just changed in such an incredibly dangerous way with young people. So, Mr. Fontenot, there was a time I just saw you some years ago that on that screen. There really wasn't even a question. Everyone, I cannot imagine, state's attorneys were recommending that youthful offenders probation was working in that store. And they now just trying to go to work such an incredibly dangerous way. And he has 3 young people come in and do not just I just saw grab a little quick something and run out, but terrorize him. I cannot imagine the fear that pulling him around, yanking him around, putting guns in his face. All 3 of that he now has just trying to go to work. Make a living. Also, in addition to 3 PSI, get people come in and not just grab a little quick something and run out and jump people, but terrorize what's been happening in the jail. So it makes it very difficult for me pulling them around, yanking them around, putting guns in his face. And all 3 of you can follow the rules because you can't even follow the rules. Also, in addition to the PSI, the precinct report shows that you're a high risk level, which tells me that after they've looked at everything that. So it makes it very difficult a good likelihood of.
This is the moment the sentence starts feeling inevitable. The judge is not only thinking about this robbery, but also about the fear the victim experienced and the growing pattern of violent crimes.
DCCR 1759. This is somebody that's going to get out and behave guilty and follow the rules because you can't even follow the rules. I'm going to find sufficient evidence to find you guilty, and at this time I'm going to find you guilty of aggravated robbery. Shows I'm going to sentence you to a high risk level, which tells me that after they've looked at everything that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So, in cause number 25, DCCR 1759, years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to find you guilty of aggravated robbery.
Those jail reports become a major turning point. When someone cannot follow rules while already in custody, convincing a judge to grant probation becomes incredibly difficult.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. I am making an affirmative finding of a deadly weapon. Mr. Fontenot.
You can immediately hear the emotion in the courtroom. For the family, everything changes in one sentence. But from the judge's perspective, this punishment reflects the seriousness of an armed robbery involving multiple offenders.
Better. That's going to be up to you, okay? You can go back with the bailiff. Term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. This was not an agreement. You have some rights to appeal. I have also handed you a written admonishment regarding ineligibility to possess a firearm or aggravated robbery. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You can talk to Mr. Rojas about any questions you have about that. And I am making an affirmative finding of a deadly weapon or some evidence. Mr. Fontenot, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? One was the, you can go back with the admonishment.
Even after imposing 25 years, the judge leaves the defendant with one final message of hope. The sentence is severe, but the court is also saying that redemption is still possible if he chooses a different path.